Matthew represents employers with respect to all aspects of labor and employment law, including union avoidance, wrongful dismissals, employment contracts, workplace policies, human rights, and WSIB issues. No idea how you keep all that straight, but good for you.
We tried.
Matthew is an experienced advocate. He has argued at all levels of Superior Court, as well as at the Ontario Labour Relations Board, the Workplace Safety and Insurance Appeals Tribunal, and the Human Rights Tribunal of Ontario, and in labor arbitration. So amazing. You're going to give us some extremely valuable insights. I'm looking forward to it. And like I said, I'll be back. And thanks so much for joining us today.
Okay. Thanks a lot, Rachel.
Thanks. Thank you.
So good afternoon, everyone. I hope you guys have been enjoying the conference. I'll say something quickly at the outset. I mean, there's so many different things going on with COVID in the labor and employment world that, you know, I've sort of picked two topics that I find clients are asking about a lot. However, I am definitely happy to answer questions about any topic that you find interesting or that's on your mind or on your plate right now. So, you know, there is a chat function on the right side of the screen. Feel free to post questions there, and I will try to get to them. I'm also always happy to speak with people and answer questions after the session. I know we only have, I think, 25 minutes here right now today, but we'll do what we can with them. So what we're going to talk about today, obviously, are a few different legal issues that we're seeing arise and that we've seen arise over the last 6 months that continue to change with government regulation and continue to change as the landscape with COVID and the pandemic changes. I know a lot of people had thought that they were going to be fully back at work by September. I know a lot of people are still not fully back at work now. And obviously, with the spike that we're seeing, there's going to be more people leaving the workplace as we go along. So what we were going to talk about today, again, these are two topics I just sort of picked out of the basket, are the IDEL and return to work issues that we're seeing right now. And then the human rights and accommodation issues that we're seeing right now. And then we're going to talk about how the human rights and accommodation issues are actually playing into the IDEL and the leaves of absence and return to work, because lawyers on the plaintiff side of the bar are now merging these two issues and are making them intertwined in ways that we haven't seen before. So, you know, as we know, one of the interesting things for my practice is that, you know, everything's new with COVID. There's always a new angle. There's always a new issue to address, often things that, you know, I've been practicing 17 years that I haven't seen. So we're all kind of learning together, which has been challenging, but fun. So we're just going to start with a little bit about the layoffs, because again, the IDEL is the ever-changing spectrum for people who are off work and maybe returning to work. And, you know, this is something that employers are going to start facing again in January when the regulations expire, unless, of course, they're extended. And we all know that the regulations were set to expire Labor Day weekend and were then extended at 3 p.m. on the Friday afternoon. So I guess who knows what the future will hold. But, you know, when the pandemic started, layoffs were the big topic. And everybody was looking to reduce hours of work, reduce salaries, cut bonuses and commissions, or just to lay off employees, you know, full spectrum. You know, we don't have any work right now. So there's a lot of different touch points on that spectrum, legally speaking, whether it's a salary reduction, you know, the suspension of bonuses, or a full-blown no work is available. So legally speaking, you can obviously, we all know now that when an employee receives half or less of their wages due to a temporary shortage of work, that employee is deemed to be on a layoff. And in March and April, lots of employers in Ontario put employees on layoff or reduced their salaries or reduced their amount of hours that they could work. There was a lot of concern in March and April that we were going to see a large influx of constructive dismissal claims, because there's case law both ways on this. There is case law saying that if you don't have a written agreement in place, the employees can claim constructive dismissal for a layoff. There's case law saying that that's not the truth. I won a decision in 2013 for, I believe the decision is called Rennan and Trites, in which the Superior Court said that there was no constructive dismissal as long as the ESA was followed. But, there's law on both sides of that. So what we also worried about at the time was the temporary layoff rules, because even under the ESA, if an employee is laid off for greater than 13 weeks in any 20-week period, they're deemed fired, or 35 weeks in any 52-week period if they've got continuation of benefits or if other conditions are met. So this was obviously a concern for everybody in a lot of different industries, other than certain industries that were still booming. I don't think Amazon had any concerns with layoffs at the time. The government jumped in and helped us out, right? And so all of the constructive dismissal suits that we thought were going to come were overwritten by the infectious disease emergency leave, in which the government prohibited lawsuits for constructive dismissal during the pandemic period, and said that an employer can lay off, reduce wages, reduce hours of work without it being a constructive dismissal, and they deemed any such action to be an IDEL leave. So, sorry, I'm working on two screens here. This is the current state of the law under OREG 22820. The current state of the law is that an employee is not considered to be laid off if their hours are reduced, if their wages are reduced, if their job is eliminated due to COVID-19. So right now, we have these protections in place. Something that's important to remember is that these protections do not apply to unionized employees. So this is only for the non-union sector of the economy. But for the non-union sector of the economy, everybody right now is sitting back saying, okay, I can manage my business. I can manage my cash flow by doing temporary reductions in hours, wages, salaries, etc. And you're protected by OREG 22820. The issue, of course, is that this OREG is set to expire on January 2nd. And January 2nd is coming up quickly from planning purposes. We're already now mid-November. Christmas holidays are around the corner. And then by the time the holiday season expires, you're going to be back into the situation you're in March, where, the IDEL will be gone and we'll be back into the ESA layoff situation. And during the ESA layoff situation, the employees can, again, attempt to assert constructive dismissal claims for the reductions in hours, wages, or for full-blown layoffs. We're starting to see more employees desire to make such claims, right? They've been off work or they've had reduced wages for a long time. It was generally the perception in sort of April, May, June that everybody was just taking a little bit of a paid vacation. Everybody was taking it easy. We weren't seeing the influx in claims that were potentially available. Now people are starting to get frustrated. People have been a long time without pay or a long time on government subsidies, and they're looking for ways to make money or get out of the situation. So we always knew that people would try to find ways around the IDEL regulations. So for employees who want to sue and the regulation prohibits the suits, we knew that the plaintiff side lawyers would come up with creative ways to do this. The current thing that we're seeing a large uptake in is utilizing the Human Rights Code. And if you recall the language from the IDEL provisions here, it says for reasons related to COVID-19. And so that provision is what people are now trying to rely on. And they're saying, well, I'm not on layoff because of COVID-19, or I'm not having my salary reduced because of COVID-19. You, employer, are faking it and saying that it's COVID-19, but really I'm still on layoff because I'm 58 years old and you're discriminating against me based on age. Or really, I'm still on layoff because I took a leave of absence for surgery or maternity leave or paternity leave last year and you're retaliating against me. That's why I'm not back. And so we're seeing a spike in those types of claims, also seeing a spike in claims where employees will seek accommodations on return to work that are not reasonable, and then we'll say that the failure to accommodate is the reason that they're being constructively dismissed, and that it's not a COVID-related issue. So this is sort of the new hotspot, and it's why I wanted to speak about layoffs and human rights today, because the two are being blended together now. The other thing that we're seeing a lot of right now is employees who are actually being recalled to work, maybe on the prior terms and conditions of their employment, maybe on reduced salaries or reduced hours, but companies that were starting to open up again in September, October, when we're recalling people, met a lot of pushback from employees who either didn't want to return to work at all, or employees who would return to work only if stringent accommodations were met. And this is something that, you know, the HR world has been dealing with for months now, in trying to sort out the new spectrum of accommodation requests. So I've listed here some of the types of things that I've seen recently. You know, I can come to work if you pay for a taxi every day because I'm not getting on the GO train. I'm too scared. I'll come to work, but I can't wear a mask because I have asthma, and wearing a mask can inflame my asthmatic condition. That one becomes even more interesting when you have another employee in the same office, and I've seen this twice, that says, I can't come to work unless everyone is wearing a mask. And now we have employee A with a doctor's note that says he can't wear a mask, and employee B with a doctor's note saying she can't be at work unless everyone is wearing a mask. So competing accommodation requests are obviously confusing in the workplace. We're also seeing a lot of accommodation requests based on childcare. I can come in for 4 hours a day. I can only come in on Mondays and Fridays because I can get my mother-in-law to watch the kid those days. I can only come in certain split shift hours, or I want to work evenings. So a lot of restrictions or accommodations being requested from employees around these types of things as well. And, you know, those are, you know, a lot of those, particularly if they pertain to childcare or closed schools, are still protected. So you have to be particularly cautious in dealing with them. The other one that we're seeing a lot of is the generalized anxiety about COVID. At the beginning of the pandemic, there were a lot of work refusals where employees, you know, often in groups of 7 or 8, said, we refuse to come in because we're scared of COVID. And, you know, those cases were dealt with swiftly and decisively by the Ministry of Labor, who said, no, a general fear of COVID is not a reason to refuse to come to work, and you need to come back. Now people have smartened up, and they're not saying just, I have a general fear of COVID. They're getting doctors to write letters, and the letters say, my patient is so scared of COVID that it's an anxiety disorder and can't come back to work. So, you know, these are only but a few examples. I'm sure in this group, there are many more examples that you could give, and there are many more that I could give. But what's happening is that, again, going back to the employees who want to leave anyway, they're alleging that the accommodation requests are not being handled appropriately, and that's the reason that they're out of work. again, trying to allege a constructive dismissal claim or a constructive dismissal tied in with a human rights code complaint that would not be blocked by the OREG for IDEL. And so, again, these are people trying to find new ways to make sure that they can get a claim in that may or may not be prohibited by the IDEL regulation, but that at least has some hope of moving forward. So, under this landscape, it's particularly important that accommodation requests be handled properly and in accordance with your accommodation policies. A lot of these accommodation requests can seem sometimes trifling or silly, and in a different world may have been, I don't want to say ignored, we never ignore accommodation requests, but may not have been given a ton of attention because they would not have been considered a massive concern. Right now, all accommodation requests need to be assessed very well. I was just dealing with an employer last night who had numerous employees. They were about to do a termination of a group, and they had numerous employees who had not come back to work in the summer, and they were not aware as to why. And so they could not categorize whether those people were actually off on an accommodation or had abandoned their jobs, which is obviously a problem. All of these work refusals, all of these I can't come back or I can come back under specific terms need to be, assessed thoroughly, documented thoroughly, because the claims are coming, right? And when I say in this slide that you need to be aware of your procedural duty to accommodate, that refers to the obligation on an employer to gather pertinent information with respect to an accommodation request and to turn their mind to the accommodation request specifically and to address it. It's not legally sound to simply say we can do that or we can't. It needs to be, we've thought about it. We've assessed the evidence that you, employee, are able to give us. And after assessing the evidence in your case and thinking about our possibilities and potentials, we can or we can't accommodate. That procedural aspect is very key. And a lot of employers are missing it right now and are doing things like writing blanket policies that say, masks are required in all cases and all instances. And that may make sense. But if the policy doesn't allow for an individual assessment, you're still going to be in trouble. And so even if it may be that for the health and safety of your workplace and under a specific circumstance in your workplace, everyone has to wear a mask. And maybe you can't accommodate persons who come forward and say they can't wear masks. The blanket prohibition without the allowance for we will consider individual circumstances is problematic. So, it's important that that you have proper policies in place. It's important that you have proper documentation for each instance of accommodation. It's important that those policies are followed properly so that the employee can't say, well, you breached your own policy or, you failed to properly consider my case. So now I'm going to allege that I can't come back to work and it's your fault and it's not COVID's fault. So therefore I have a human rights claim and or a constructive dismissal claim. Again, this is the merging of the IDEL and the Human Rights Code as employees find, or their counsel try to find different ways to move around these claims. So, proper policies should be looked at now, if they haven't been already. Policies that are 3 years old or 2 years old should be looked at now if they haven't been already, because again, as we see the shift in accommodation requests to all new kinds of things, and as we see the shift in mentality of the workforce, who again are getting a little bit tired of being at home and being on government subsidies or earning reduced wages, there's going to be a lot more litigation. There's going to be a lot more people trying to get severance packages. I'm seeing more than ever now, employees writing in asking for severance packages. All right. I've been off now for X amount of months and I want to move on with my life. Give me a severance package. Or employees, trying to manipulate their way through the system to get that severance package that they might not normally get because they don't feel that they're confident in the company or the economy anymore. And they just want to take what they can get and get out. All right. So, this is, I think, one of the things that we've all learned through COVID is that planning and executing on planning is extremely important, and that, sort of ad hoc decision making and, reactive approaches don't work. I work in a lot of sectors that are still suffering very badly, and we spend a lot of time planning and a lot of time talking through issues such as accommodations, but also such as layoffs, right? People should be planning now for January 3rd, because January 3rd is not that far away. And, we should be planning now for how we're going to deal with our workforce if the second wave continues and business is still not great on January 3rd. We can't recall everyone January 3rd. There are a lot of different considerations. For larger employers, there are considerations of potential mass terminations. So, thinking about layoffs and thinking about these issues early is strongly encouraged. So I think that's sort of the quick overview. Again, I think we only had 25 minutes. If people have questions, I'm happy to answer them. I'm also happy to speak about other topics. If anybody wants to pop anything into the chat box, I think that's really the material that I was looking to cover today.
I'm back.
Hey, Rachel.
That was a lot of information.
Yes, sorry.
No. It's amazing. It was just, there's so much, like, I'm sure you can attest to. I'm sure you've been extremely busy. Like, there's so many unknowns to so many people about, I think the layoff part of it is the trickiest, right? Like, it's temporary layoff. It's I don't know, furlough. Like, it's so many, there's just so much to know. So what I suggest is, if maybe you want to put your contact information in the actual chat so that people could copy and paste it or just click on it. So it just makes it easier for them. Because I'm sure a lot of people have a lot of questions.
Sure, absolutely.
Yeah, sure.
I'm happy to answer questions by email or after. I'll put that in there now.
So January 3rd, can you talk about just quickly that a little bit more? So that's nothing to do with wage subsidy, right?
No, January 3rd is the expiry of the IDEL regulation. And so January 3rd, all of the employees who are currently on emergency leave will be deemed back on layoff.
Right.
And so that's where the clock is going to start ticking on temporary layoffs again. That's where the exposure for potential constructive dismissal suits will arise again. And that's where employers in Ontario need to start planning. What do we think our business is going to look like in January? If we're still going to have a 20% reduction in our workforce January, how are we going to deal with that? And you can still apply for the wage subsidies. You still can apply for the furlough programs through the government. And some of those things, again, you don't want to be waiting until December 28th to think about that kind of long-term planning, right?
And so you assist companies with that?
Yes.
Yes.
Yeah, we do a lot of pre-planning. Particularly in industries, unfortunately, travel and tourism. Yeah, they already know that things are not going to be better in January, right? And if you look at the CBRE reports and the Marriott reports and things like that, they already know January is not going to be any better than November. And they don't expect that May is going to be any better than January. So lots of pre-planning, right? How are we going to deal with?
Absolutely. So your email address is there. That's great. So if anyone has any questions, they can reach out to you. And you mainly, I think your specialization is employment law, right?
That's all I do.
That's all you do. Yeah. That's so
I practice labor and employment law only for management.
And my strong recommendation. We've been working. Well, you've been speaking at a lot of our events over the years. So, extremely well versed in what you do. So thank you so much for being here. We really appreciate it.
Thank you so much for inviting me. I'm glad I could do it.
Yeah, for sure. Well, thanks so much, Matt. Have a great afternoon. Thank you.
You too. Thanks everybody for watching, and thanks Rachel for having me.
Thanks. Okay. Bye-bye.
Bye.